Hello, my name is Robert Church. I'm the Administrative Law Judge for the Orem City Administrative Court. You've just completed an online rights advisement and acknowledgement form. While I'm not going to go over each of those rights with you at this time, I do want to highlight a couple of issues. Appearing in an administrative court has no criminal ramifications. In other words, if the court issues any kind of an order or a fine, that does not show up on any kind of a criminal history or background search. The only way that you could be charged criminally for anything that occurs in this court is if, after the court issues you an order, you fail to comply. At that point, the city, in its discretion, could choose to charge you with a Class C misdemeanor, failure to comply. The burden of proof in an administrative hearing is called preponderance of the evidence. When looking at the scales of justice, preponderance of the evidence is just enough to tip the scales one way or the other. So as I said, the burden on the city is very low. The city will present evidence through its witnesses. Evidence may take the form of verbal testimony, documents, photographs, videos, and any other evidence that the court determines is relevant. At the conclusion of the city's evidence, you will have an opportunity to ask questions of the city's witnesses. After the city has presented its evidence, you will have an opportunity to present your evidence. It may also be the same type of evidence, verbal testimony, evidence, photographs, documents, and anything else that you or the court determines is relevant. Prior to you or the city's witnesses presenting any evidence, I will place you under oath to tell the truth. By virtue of you appearing in an administrative court, you are now under the jurisdiction of this administrative court. If the court issues an order to the city to go onto your property to abate a nuisance or to take any other type of action, the city may do so. You need to understand that if they enter your property under a court order, that is not considered a trespass. Many people don't understand this principle, so I want to make sure that you do. If you are dissatisfied with any ruling of the court, you may appeal the court's decision. To appeal the court's decision, you must file an appeal in the 4th District Court, which is located in Provo, not across the breezeway here from the City Center in the Orem City Justice Court. You must file an appeal within 30 days of a final order of the court. If you wait until day 31, you have waived your right to appeal. So please be mindful of that 30-day requirement. All court orders are sent out via email. Please make sure that the city and the court have your current email address. If your case is not resolved at your first hearing or additional time is granted to resolve any issues with your property, you will be required to return for a review hearing. The review hearing is where the city will present any evidence. Evidence as to whether your property is now in compliance or what additional steps must be taken for the property to come into compliance. The court will review any previous order or orders with your case and make any additional findings or orders in order to bring your property into compliance. The court may also order fines, fees, or costs to be paid. If the property has been brought into compliance, the court will issue a final order in regards to your property, including whether any fines, fees, or costs are due and owing. And once those fines, fees, and costs have been paid, the court will issue an order dismissing your case. If after reviewing the rights form and watching this video you have any questions when you appear in court, please let me know. Thank you and have a great day.